Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Oh, getting commentary on the case. Dati mihi Anglican for his service Latino.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. It's good to have you here this morning. It is Podcast Thursday today. Podcast Thursday. If you don't know what that means, you are in for a treat. I won't string you along, but I think it'll be worth it. When you melt it all down at the end, I think overall it'll be a wonderful treat. Anyway, let's see. Did I spell read wrong? Well, that way she can't sue me. I spelled read with 2 E's. Like the plant. There we go. Thanks for the correction. All right, good morning. All right, can somebody give me a 401k? No, never mind, not a 401k. I know a 401k update. It's terrible. Can someone give me a World Cup update? Why did I think 401k? How do you confuse your retirement savings with the World Cup? This is how much of a sports fanatic I am. Those two, like they're interchangeable for me for some reason. USA won yesterday. Who were we playing? And who do we play next? Or is that decided yet? We have to wait for someone else to play and then we'll decide. Carol Mellenfont says, RA did a great job on Court and Confidential last night. Informative real-time coverage. That was a blast. I like that happened right as we were going live. Yes, we did get the sentencing on the Courtroom Confidential channel. You got to go watch it over there. We're not going to cover it here. But the jury came back with sentencing. When is the Karen Reed drama going to stop? Never. We live here now. Next match is Belgium. Ooh, Belgium's good. Isn't Belgium good? I think Belgium's good. They do 2 things really well over there. One has to do with food and the other has to do with football. And I think we're doing the football thing. Let's see. We've got they're okay. All right. Key player got a red card, could be out against Belgium. That sucks. Man, who invented these red cards? It ruins everything. Mexico is kicking butt, and it's a huge deal down here. Oh, that'd be awesome. Look, and anyone winning the World Cup, it's awesome to watch the team, the path they get to get there. Bosnia have my crew, or Bosnian win-win for them. They are now U.S. citizens. Cool. Ricky says it's Karen Richins and Kouri Reed. I'm going to make that mistake several times today. I'm positive because we have both of them on the schedule for today. But we have a few things to catch up on, some things that are happening just recently, last couple of days, some filings, some spiciness. A wild hearing that's only 15 minutes long for Karen Reed that happened the other day. We're gonna play that for you and try to figure out the heads or tails of why that happened and what it's about. Court watcher Denisha says, "Come on, you're stalling. Come on, give me the internet." There you are. Thank you, Mrs. R. I appreciate it. Appreciate you. She's cleaning up my mess that I left in the hallway. She's bringing cables in. Thank you. Yeah. Thanks for not throwing them. Is what I'm saying. Away or in here. Either one. Throwing them would have been bad. But thank you for not doing that. All right. Court watcher Denisha. Congratulations. Might we have chat on screen? Oh, I haven't even. Look at this. My chat buttons aren't even turned on. I've got a whole other computer I have to turn on to make that work. Hold, please. Powering it up. And it's up and it's on. That quick. Whew. Love Macs for that reason. All right. Do my eyes see a bottle of Mountain Dew on the desk? Don't know what you're talking about, Britta. Good question, though. Court watcher Denisha, you were first in chat, and you said three things. This was the third you said. You said, I think I'm first, but I liked that better than the that you started with. We're going to send it to you to internet ownership. Everything IP related worldwide is your responsibility. Congratulations, Court watcher Denisha. This is not your first time. This is not your first offense. You are, in fact, a repeat offender, habitual offender, if we use the technical term. So you know what's coming to you, and I can't get in the way of justice. You are the internet owner for today. Congratulations, Denisha. All right. When does your desk counter arrive? I wish they'd tell me. Here's what happened. I ordered it. I researched everything, read every page on their website. And, oh yeah, we've got to sing. I read every page on their website, and I'm like, okay, cool. And they're like, we'll ship it. It comes out of France. It's great. It's like they made the Eiffel Tower. I mean, and the Statue of Liberty. They make good things in France, right? And baguettes. I'm like, cool. And it's going to ship. Here's the cost. It was 20% off, which is like my favorite. And I'm like, yeah, it's going to arrive via FedEx or DHL. I'm like, okay. And I'm still waiting for the shipping, the tracking confirmation. I haven't got one yet. Next email I get is from the owner of Smirl, which I think is how you say it. It's like, hey, thanks for your order. Just as a reminder, as we told you on the main page when you were ordered, there are going to be tariffs.
Happy birthday. You look good.
A tariff, an import fee is going to be applied to your order. I'm like, as you told me, what? So there's that 20% off. That's going to be applied as a customs duty tax on it. I'm going to get some random bill from FedEx or DHL at some point. Either they say after the delivery, which I'm like, yeah, really? How do you collect on something after the delivery? You have to hold it hostage. So I'm waiting for someone to tell me I owe money, so that they will release it off the boat on the dock or wherever it is. So that's what I'm waiting for. But that's where the counter is. But let's get to the birthdays, because we have to do that. We've got some funny and some fun and some interesting things to watch and talk about today. Some documents to read. And, of course, it is a mod's birthday tomorrow. We're going to celebrate it today because tomorrow is the 3rd of July. Guess what I'm doing? I'm going into, like, Raleigh, Apex area. There's a drone show, like a fireworks drone show thing. I've never seen one. I fly drones. I've never seen a drone show live. So I'm going to go there. I don't know. Maybe we can film that. Do you think they'd let us? Probably not. Anyway, so we're going to go there, and then we're headed out to a 4th of July celebration on Saturday, I think on the Outer Banks. Not sure. We'll figure it out. All right. Anyway, birthdays. I'm sorry. We're stalling. Let's get this done. Alan, Angela, Katrina, Lindsay Ross. Is Lindsay and Lindsay Ross the same? We'll never know, because Lindsay Ross will be like, I don't know. Who's Lindsay? Ruby for Justice, Josh Hutchings, that's our mod. Delina, and Welsh Lady Reads. Holy cow, that's a mouthful. That's a lot of birthdays. We start need to requiring Social Security on this birthday form. I think a Social Security number, date of birth, and mother's maiden name. If we can get those three added to the form, Greeners, that would solve all of our problems. I mean, like, whew, cha-ching. All right. Here we go. Date of birth is kind of included on the form. Yeah, there's that one. Your high school, name of your high school or your high school mascot, that also might be added on there. All right, let's do the birthday things. Josh has this all prepared for us, so let's get this ready. I have not had any Mountain Dew yet. Zero, none. I didn't even eat my exhibit from our demonstration yesterday. So here we go. Wherever you are, if it's legal, if you're driving, obviously, don't follow my advice strictly. But wherever you are, if it's legal and you're able, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. Josh says, hurry up, I have things to do. All right. We're going to sing to all these people. Two verses. Happy birthday to you. Happy birthday to you. Happy birthday, dear Alan, Angela, Katrina, Lindsay Ross, and Ruby for Justice. Happy birthday to you. So tomorrow we have Josh Hutchins, Dylan, and Welsh Lady Reads. I think that's how it works. We sing to the ones that have a birthday today already, and now the second verse is tomorrow. So pretend this is tomorrow, Josh. Ready? Happy birthday to you. Happy birthday to you. Happy birthday, dear Josh Hutchins, Dylan, when Welsh Lady Reads. Happy birthday to you. So this is Josh's hero, who I think he's met. May he rest in peace, Chuck Norris. To everyone who's celebrating their birthday today, happy birthday. I realize there are a million places you could be and a billion people you could have celebrated with. Not celibate, but you can be celibate with all of them, just for the record. I mean, we're not going there, but you chose to be here with us today. The privilege, pleasure, the honor, the joy, that's ours. Hopefully we can turn that joy back to you and make your day just a little more special. Or begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Annie's Grill, Bob Evans, and Cracker Barrel. Whoo! And I have to scroll up. Sub Rosa, this is awesome. This is the face blowing out the birthday candles. Oh, that is just so cool. Thank you. Happy birthday. Yes, and please be celibate with most of those 1 billion people that you could have celebrated with. I need to be celibate. Having babies back to back. Celibate on your birthday. Just with, like, most of the 1 billion. That's all I'm saying. Most of the 1 billion. Drum solo. My knuckle on my desk. It was to the rhythm, but it hurts. It was like a whack. Yes. Happy birthday all while we were celebrating. Those were Thursday. Saturday birthdays. I was only on July 3rd birthday. I have a nephew due in the first. I hope you can. What? Oh, those are Thursday through Saturday. This makes more sense now. Welsh Lady Reads is on Saturday.
Birthday.
Josh is on Friday, which is tomorrow. And the others were okay. Thank you, Josh. You did the right thing. And I misread it. Now that I'm thinking back in my mind's eye, I saw you had the lines of delineation in place properly on the message, and I skipped to the second one. But it's all good. Ari is the first person to ever hurt himself air drumming. I think I've thrown out my shoulder as well, so there's like a double injury. Wait, why is RA giving advice in this category? Kathy, it's good advice. You've got to admit. When I say there are a billion people you could be celibate with, the alternative, I don't think is good advice. Kouri Hill, member for 30 months. OG, 30 months. I turned 30 on July 30th. That's awesome. Happy birthday soon, Kouri. Thank you very much for your support. Love that courthouse. Judy M, member for 31 months. Happy 31. Love and hugs, y'all. I love the y'all. Thanks for dropping that one as well. OG there as well. Are we off on Friday for the holiday? I think so, unless we see something big. Because what we have next week is Tyler Robinson starting. That's going to be a big case, a big deal. Baby Shark, hey! Member for 30 months. OG, I'm coming for that red courthouse. I'm coming for it. I think you've passed the red at that point. You've passed it. You've got pink already. So, Brandy Meyer, member for 33 months. Love being in this family. OG as well. So many long-term OGs coming in right now. Brenda Meyer, congratulations, 33. That is really cool. You guys are all amazing. I appreciate so many of you who showed up and gave support and just kind words and said hello or just clicked the like button for Josh at Courtroom Confidential. I did tell Tiff after the show, I'm like, hey, we obviously I love doing it. So thank you for the invite. I really appreciate going on there. They run such a professional. Red is 36 months. I didn't know that. Me too, says MSCJ 1975, member for 38 months. OG, that's the red one. I had it wrong. I thought it went pink then red, but I thought it went red then pink. Now it's pink then red. Thank you, Kim. So you were right. You were right about that. Anyway, the Courtroom Confidential team is amazing. Josh, Tiff, and Kai. She had her full name yesterday, and I can't remember what it was. I have to remember what her name is. The best assistant ever known to man. She's amazing. I'm trying to get through this. There's so many membership anniversaries. Aunt Karen ones. Aunt Kareni ones. There we go. Aunt Perennials. I don't know what that is. OG, 33 months. Thank you very much for your support. And also we've got DMB, secondest member for 43 months. DMB, thanks for being here. Thank you. 42 months. The answer to the ultimate question of life, the universe, and everything. That's a little reference to Hitchhiker's Guide to the Galaxy. Thank you. Yes, 42 is the answer. And OG, OGist of OGs, maybe. Unholy Saint, member for 37 months. OG. We've got so many originals. Original goats here. Carol says, Scott, check your Venmo when you... Hey, Carol. Carol, thank you. I will do that as soon as I get rid of Josh Hutchins' hero off my page. Okay. Let me finish. Adri Horick, I need... or is it Audrey? Is it Adri? Adri or Audrey? I think it's Adri. Adri Horick says, just for you, I am eating some Belgian butter waffles with chocolate. I promised a friend that I was not going to talk about food, at least till the podcast, but it sounds yummy. Congratulations on 8 months. Those sound really good. Taz, a member for 19 months. Does 19 months count as an OG? We're counting it. OG, you're in. Okay. Courtroom Confidential. First of all, it is a privilege and pleasure and honor every time I go over there. Josh is just... He is, from the first time I went over and got to visit with him and see what he did and talk to him a little bit, he runs such a professional show, like because he's been there, right? He's got media experience and he's got legal experience. He knows how it should be, and he does it right. And so they plan, they got everything set up. There's a rundown. It's like a well-oiled machine. And I'm usually the fly by the seat of the pants, more of just like let's do it live and see if it works type guy. And so I walk in there, and it's just so cool to see how that works and watch it all come together, and just a very polished production. I love that. Plus, it's the quality, the content is incredible. They bring on incredible guests and me, so it was awesome. It was awesome. And anyway, since the very beginning, and they've always told themselves that, or not told themselves, but they told us that they're the fastest growing channel on YouTube in this true crime world, and I think they are. I told Tiffany last night that next time I'm on, I expect to be celebrating their 100,000 subscriber celebration because they're already in the low 90s and they're growing fast. And we've got the Tyler Robinson case coming up with Josh, who's going to be on what he does with Fox as well. He's going to be there in Salt Lake, in Utah County, actually Provo, for that one. So it's going to be amazing. Anyway, so big shout out to them. Thank you. They came in here and kindly donated a bunch of memberships yesterday as well, which was awesome. I think you're one of their OGs. I love it. I love that I am. They're just an amazing channel, and so I can't say thanks enough. If you don't follow them, the Courtroom Confidential is probably the best channel I've seen that quickly keeps you up to date with everything that's current in true crime. I love how they do that. I mean, they will give you the updates on all the big cases, and you choose where to go next, and you literally get to say, hey Josh, tell me about that one. He's like, okay, and he will. So it's fantastic to watch him keep everybody updated and interact, and watching his channel grow. It's just amazing. So big shout out to them. Thank you very much. Tiffany is absolutely the soul of CC. Tiffany's incredible. Every time I get an invite, it comes from Tiffany, I think. Tiffany's the one that does the scheduling and the behind the scenes, and full-time mom. She's got her hands full, and it's just, I love, they're a dynamic duo. They're amazing. Northwest, thank you very much. Jay McCarthy World gifted 5 memberships as well. Thank you very much. They're so lovely online and in real life. Yeah, just awesome people. Let's go to. Did I miss something? Okay. Okay. Well, we're going to get to that, but that's the last thing because I don't have it ready yet. Let's start with Karen Reed. We've got a 15-minute hearing that we almost started yesterday, and then things broke in the case we were following, so we had to sort of go backwards a little bit. So we're going to rewind just a minute in the hearing that happened yesterday. That's going to be on Channel 7. Right?
Yes. Your Honor, may I proceed?
Yes.
Your Honor, for the record, Civil Action 2483 CV 0692. This is Paul O'Keefe, individually and as personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality LLC, doing business as CF McCarthy's et al.
Okay, pause. Is he talking faster, or did I have him on high speed? Because they are hauling butt, and they already talk fast up there. Okay, I had him on high speed. I'm slowing that down.
Hear ye.
Yes, that's more the pace. That's what I was more expecting. So we'll go ahead and do it at a slower speed.
Your Honor, may I proceed?
Yes.
Your Honor, for the record, Civil Action 2483 CV 0692. This is Paul O'Keefe, individually and as personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality LLC, doing business as CF McCarthy's et al. Your Honor, with your permission, at this time I will call the names of the attorneys in attendance and ask that they state that they are present for the purposes of the record.
Just like in elementary school. Go for it.
Attorney Brillahante.
Present, Your Honor.
Here.
Attorney Horwitz.
Present.
Attorney Fell.
Present.
Attorney Buck.
Present.
Attorney Diller.
Present.
Attorney Beaton has been excused, Your Honor.
Lucky.
Attorney Holstag.
Present.
Attorney Rose.
Present, Your Honor.
Attorney St. George.
Present, Your Honor.
Attorney Donovan.
Present, Your Honor.
Attorney Deely.
Present, Your Honor.
Attorney McCaffrey.
Present, Your Honor.
Attorney Hassett.
Present, Your Honor.
Attorney Maravellis.
Present, Your Honor.
Attorney Shipley has been excused. Attorney Tang.
Present, Your Honor.
Attorney Bell.
Present.
Your Honor, Attorneys Little and Mason are appearing via Zoom.
Attorney Jackson's getting some free publicity as well.
Attorney Jackson.
Present.
Attorney Seligson.
Present.
And Attorney Rosenberg.
Present, Your Honor.
He's got a background that
Sit
says
down. Thank
Attorney
you.
Jackson or something.
So thank you, counsel, for being here. I scheduled today to be in person because of the significance of what I was advised of last Friday, and because I find the quiet solemnity of the courtroom is a good reminder of the dignity by which courts are supposed to function.
He hates Zoom.
One commenter describes how every high-profile case now unfolds in 2 arenas, one governed by procedure and precedent, and the other by pixels, edits, and algorithms, and how the courtroom has become content and the law has become a spectacle. I
And
recently
you
held
are
a
the
hearing on a
center
non-party motion for a protective order. I required the moving party to provide certain information. Such material was filed together with the motion to impound. A hearing that included the motion to impound was held on a Monday morning. I allowed the motion to impound during the hearing. The affidavits of the moving party and the attorneys were impounded. Following that morning hearing, I found that there was insufficient information to support a delay in the deposition of the non-party from going forward.
That was Proctor.
However, I further found that given the claims made in the filings, I would delay making a final decision on the motion until later that day to give the non-party's counsel the opportunity to supplement the record before me. I scheduled the matter for further hearing that afternoon at 4:15 with the expectation that there would be additional filings. At 2:22 p.m. that day, the non-party's attorney emailed the clerk of this court and all counsel of record, excepting one, additional materials in support of the motion for a protective order. The filing included a motion to impound additional materials. Exactly 30 minutes after the email to counsel of record of the additional material, which included sensitive and private medical information, similar information to what was in the exhibits to the filing and marked provisionally impounded, was posted to an X account at 2:52 p.m.
Who posted it?
Upon learning this information, I ordered that the parties and counsel provide a certification to the court as to all facts known to them as to any dissemination to anyone other than parties and counsel in this matter of any of the contents of the material impounded on June 8, 2026, and I scheduled this appearance for today. I received certifications from all party and counsel, 32 of them in total. No one apparently has disseminated, nor are they aware of any facts regarding the dissemination of the contents of impounded material to any person or entity other than the parties and counsel in this matter. However, somehow, an ex-account holder, not part of this case, apparently received information that was at least provisionally impounded. Orders of the court have been violated either directly or at the very least in spirit.
In spirit.
If these orders are to have any effect, all parties involved must operate with integrity. Rule 13C of the Uniform Rules of Impoundment Procedure imposes a duty on all persons to protect the confidentiality of impounded material. Additionally, Rule 3.6 of the Rules of Professional Conduct prohibits lawyers from making extrajudicial statements that they know or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding.
That's what Tyler Robinson case
In
just
cases
had.
like this, where all parties involved are aware of the public attention, I expect that everyone is taking every precaution to preserve confidential information, to follow the rules of the court, and to adhere to my orders. Because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. If necessary, I am fully prepared to make such order permanent as permitted by Rules 26 and 30. To any issue counsel may raise as to the management of discovery issues being within my discretion, I invite you to look at the following cases.
Says if you take issue with this,
In the
there's
2003
case law.
case of Buster v. George W. Moore, Inc., 438 Mass. 635, the SJC stated at page 653, in general, discovery matters are committed to the sound discretion of the trial judge. In a 2002 appeals court case, Mattoon versus the City of Pittsfield, 56 Mass. App Court 124, the court stated at page 131, trial judges have broad discretion to make discovery and evidentiary rulings conducive to the conduct of a fair and orderly trial. In the 1987 case of Solomon A. versus B. Krul, 399 Mass. 790, the SJC stated at page 799, The conduct and scope of discovery is within the sound discretion of the judge. In Cronin versus Strayer, 392 Mass 525, a 1984 case, the SJC stated at pages 535 to 536, we remind judges that the scope and timing of discovery is within their discretion, and the prevention of discovery abuse is sufficient justification for the authorization of protective orders. With this authority at hand, judges should not hesitate to exercise appropriate control over the discovery process. And finally, in the 1987 case of Campagna versus the Board of Directors of the Massachusetts Housing Finance Agency, 399 Mass 492, the SJC stated at page 503 that Rule 37 affords a judge broad discretion to impose whatever sanctions are just in order to ensure that the discovery process operates efficiently. The malicious publication of private information concerns me. Whatever opinion that one may have of a non-party, even if warranted, such an opinion does not allow for the disparate treatment of such individual. All people deserve fair and equal treatment in our system of justice, regardless of any personal characteristic, as abhorrent as some of them may be. What I am looking for is for the parties is adequate assurances that their discovery served justice and not any desire to weaponize the rules for pettiness and profit. If the parties and lawyers would enter into an agreement to hold private, personal information in confidence, and if the terms were acceptable to me, I would consider entering it as an order of the court so that any violation would be grounds for a contempt finding and appropriate sanction, including dismissal or default. Such an order would need to be more than a stipulation that deposition testimony can only be used for the purposes of this case. I encourage the attorneys to confer and to seek to reach an agreement. In the absence of an agreement, I will consider whether to enter an order based on my plenary authority to control, manage, and oversee the conduct of discovery. While you are conferring and seeking to reach an agreement, I will again remind you, as I have quite often, that the discovery clock is ticking. My final request to counsel with an appearance in this matter is to familiarize yourself with Rule 3.6 of the Rules of Professional Conduct relative to publicity. The rule sets forth a basic general prohibition against a lawyer's making statements that the lawyer knows or should know will have a substantial likelihood on materially prejudicing an adjudicative proceeding. The rule applies to lawyers who are or have been involved in the investigation or litigation of a case and their associates. As the comment to the rule notes, it is difficult to strike a balance between protecting the right to a fair trial and safeguarding the right of free expression. However, preserving the right to a fair trial for everyone necessarily entails some curtailment of information that may be disseminated prior to trial, especially where trial by jury is involved. If there were no such limits, the result would be the practical nullification of the protective effect of the rules of forensic decorum and the exclusionary rules of evidence. The rule takes into consideration that the public has a legitimate interest in the conduct of judicial proceedings, particularly in matters of general public concern. However, I'm not so sure that churning the waters to generate social media coverage necessarily can result in a legitimate interest in the conduct of judicial proceedings. Read the rule, especially if you have never done so. Adhere to it, or be ready to face the consequences for failing to do so. I remind counsel of
Shots
what one
fired.
commentator called the quiet expectation of fairness that we have as citizens. Such expectation is based on the framework the founders of our country built 250 years ago and trusted future generations to maintain. Counsel, do your part to maintain the quiet expectation of fairness. Do not succumb to the attraction of seeking to influence this case through social media. Be what a trial lawyer should be, one that tries their case in the courtroom. And remember the provisions of General Laws, Chapter 221, Section 28, relative to the oath of office for an attorney in Massachusetts, which provides, in part, I solemnly swear that I will do no falsehood. I will delay no man for lucre or malice, but I will conduct myself in the office of an attorney within the courts according to the best of my knowledge and discretion, and with all good fidelity, as well to the courts as my clients. So help me God. I wish all of you a happy 4th of July on the anniversary of our America's 250-year-old democracy. May it continue to succeed with all of us working to maintain the rule of law. Thank you.
Court, all right.
For the record, this matter is continued to July 10th, 2026 at 2 p.m. for hearing on motions to compel the criminal fourth session.
Court stands in recess.
There's no opportunity to be heard? There obviously no opportunity to be heard.
I was unaware. I'm just covering for Clerk Donovan today.
Is there an opportunity before everybody departs to let the judge know that we would like to be heard?
I absolutely.
Beep. Okay, stop. Just my first impression. That's the first time I've watched this. I haven't even listened to anyone else take on this. Initial response, that could have been an email, Judge. This whole thing could have been an email. That was a very, very expensive soliloquy. Well, no, there were people there. It was a speech. The judge gave a speech. It was a mini TED Talk by the judge. And by the way, happy birthday, America, on the end. Let's just tack that on there for good measure, because, you know, cameras are watching. Even though he talks bad about the cameras, he wants to look good in front of them, right? So you can't forget that part. This was shots fired across the bow. This was a warning to everyone. The judge apparently believes he is holds the monopoly on facts, on information relevant to this case. Let me just break the news very gently to him. He does look like he's part of the old guard. That's great. I love an experienced judge. Let me just break this very gently. How do I say this? Before evidence is presented in court, it is known outside of court.
I think I'm about to catch a whooping.
Just because somebody files something in court and says, we don't want this document out in the world, does not mean as it not got out into the world previously in any other method. It can already exist. The leak, and I don't know the information. I could care less, honestly. I could care less what the content of the leak was. I think it had to do with some sort of treatment that Proctor was getting or had gotten or will be getting or something like that. I don't care. It doesn't matter. Don't put it in chat. It's irrelevant. It was the content of a filing that was filed with the court. I checked X while he was talking, and Grok can't find anything that shows an impounded leak. Even the judge's own words basically said the information on this X account, doesn't matter whose, we think we know who, had similar information. Well, the docket request to impound is public. That was out there. The request to impound. The content, that was similar information from days before the filing. I think the judge got his panties in a bunch over nothing. This seemed to really frustrate him because he thought he was in control of everything, and he wasn't, and it makes him look silly. He initially accused all the lawyers who were summoned to say, "Prove it wasn't you. I need a sworn declaration from all of you saying it wasn't you who leaked." And they all said it wasn't me. He's like, okay. So now what I want to do is, I think I have the authority to seal everything permanently, ever, that comes into court. Any information that comes in, I'm gonna seal the whole record. Courts are just gonna go secret. Massachusetts is going dark from here on out. I don't think that's the answer. The judge didn't take that step, even though he teased it a couple times. Instead, he sort of exhorted all the attorneys, and you heard the list of attorneys. Do you know how hard it is to get 2 attorneys to agree? Try 12. If you can get all the attorneys to agree to basically the judge sealing everything permanently forever, then he would go ahead and do it. He doesn't want to just take that step because he probably won't hold up in court. Yeah. Karen Reed's team aren't allowed to continue the deposition with Proctor now. I missed that part. I missed that. Here's what I know. A bunch of text messages have come out as a result of the Karen Reed case and the cases that have stemmed from the Karen Reed case, because it has grown, and part of it is media, part of it is media personalities, part of it, the case has grown. There are more players now involved than there were before. Some of them were witnesses, some of them were suspects, some of them it's grown. The family's larger. Family reunions are going to be a little more crowded when we meet back again in 25 years and celebrate all this. But I don't think this judge can hide this. I don't think you can put this bonfire under a basket and hide the flames. Information's going to come out, and he can't control it. I don't know. I don't know what's going to happen. Does this mean it's the Karen Reed universe? I don't. Yes, it's growing. It's big. Oh. That was my Mountain Dew. It didn't spill because I had the lid on, but now it's, lost a little. Didn't hit my switcher either. That was good. So that was interesting. I think the judge got it wrong. I think he jumped to accuse the attorneys when I don't think an attorney released it. If an attorney had released it, it would be that document, right? It would be the subject to impound. Look what we got. Hot letter leaked off the press. It wasn't. It was just information that was also included in that filing that was out there. And it could have come from, everyone from Proctor himself down. It could have come from either side. There's, tons of people doing boots on the ground type investigation in this case that are, dredging up any bit of information they can get, as anyone has seen anywhere in the United States says, hey, look who I saw. Guess where I saw them. That could be the source of information. Anyway, that being said, that was interesting. We're going to jump now to a hearing for Judge Dad. I believe this is for Monday. I'm not sure if this is the spicy one you guys wanted, but it's one I found that I wanted to play. What does this mean for Proctor? I don't know. I don't know what it means. We've got another hearing coming up. We've got another date. Not sure. What's going on with Tyler Robinson? Emergency Supreme Court hearing? Yes. Cass, that was a filing. Okay, we talked about this just a tiny bit on Josh's show last night on Courtroom Confidential. In Tyler Robinson case, the defense has literally asked the judge in the last hearing to lengthen the time frame for deadlines before a hearing to allow the defense to appeal to the Supreme Court every ruling they don't like from the judge. I kid you not. That's what they asked for. So, for example, they said we don't like the fact that the media can, the day before a trial can say, hey, we'd like to cover this, and then the judge can decide, and then the media is there. They said we need time. We need time to respond if you're going to allow the media in. And the judge fell for it. He said, sure, okay, I'm going to make the media have to request to cover each hearing 14 days in advance. And then you can respond. And then we'll hold the hearing. And they said, okay, great, Judge, we'll take that. That's great. And so now that's the rule. You have 14 days ahead of the hearing. We as members of the media have to say, I'd like to cover that, please, Your Honor. And he's like, oh, you do? Okay. We'll let the defense know. We'll let the prosecution know. We're going to have a little hearing where we decide whether or not you can cover it. And defense will get to say their bit. I'm going to rule, which is usually going to be in favor of the media because there's a presumption of openness in court. And then we're going to hold the hearing. And he said, we'll just do it at the beginning of the hearing. We'll just have that quick little get-together where everything's presented. We'll call down the Deseret News photographer, who is not going to be at day one of the Tyler Robinson hearing because he missed the deadline for the 14-day. So he's going to show up on day 2. But we're going to call down the Deseret News photographer, and we're going to call the cameraman from KSL Channel 5 TV, who's going to be Pool Media, and we're going to say, sirs, did you read the rules? Yes. You read the instructions? You're not going to show the victims' families and things like that? Okay, good. Any objections? The defense is going to say, I object. We don't want media in here. It'll make it unfair, prejudice my client. It'll poison the jury pool, whatever. And the judge just says, well, I don't find that you've proven that, so media is allowed. They want, then, instead of going from that point where the judge makes the ruling to the hearing immediately, they'd like a week or so they can then appeal the judge's ruling that says, yes, media is allowed to the Supreme Court, where they can say, wait, we don't like what he did. Look at this. Didn't he do that wrong? Supreme Court, help us out. And that's basically one of the filings they filed right now, only it's not about the media. The filing that the Supreme Court is hearing right now, at least we assume they're hearing right now, they've asked for them to hear before the hearing on Monday, is will the judge's decision to allow hearsay testimony in this preliminary hearing, is that wrong, Supreme Court? Hint, it's not. It's allowed. And 2, we think that Twiggs, or Twiggy, or I don't know his name, I'm sorry, the roommate of Tyler Robinson, I think his nickname is Twiggs. I think that's what he goes by, so I'm not trying to be rude or in any way. But we think that he should have to be subpoenaed here from out of state for this hearing and not play his testimony from a prior interview instead, which has the whole confession thing on it. So that's what they're talking about right now. I don't think the Supreme Court's going to grant either one of those. The hearing's going to go forward as planned on Monday, and we're going to cover it. So that's where we are. Let's see. Don't want to be deposed in Massachusetts? Just leak it and then done. Amazing decision, Judge. Yeah. Let's see. Karen Peterson, thanks for clicking the subscribe button. We call that admitting being an addict to true crime. You're one of us now. You can never leave. Let's see. His roommate. Yes, in quotes. Lance. Lance is his name. Thank you. Lance. We're now going to jump up to Judge Dad because we have a couple things to cover. I also have a Kouri Richins. I said that right. A Kouri Richins document to cover that we're trying to put together right now. I'm looking for my copy of it, so I'm doing that frantically. Well, we listened to Judge Dad, who was going to hold a little hearing that is going to get a little bit spicy here. This was the end of the day for him on Monday, I believe. And let's give it a quick listen on 6, right? Yes. Here we go. Judge, he's just chillaxing right now. He's rethinking his life and decisions. When the judge puts his hands on his head, it's a sign. It's as clear as an umpire signaling that someone is out or safe. It's a sign, and I think the judge is going to do that.
Physical analysis, the journey. Okay. We're ready to run our table.
What's that?
For the exam, Mr. Daniel Gomez.
I'm ready.
I'm ready, Judge. Let's do it.
I was ready 3 hours ago. Want me to do them all in here?
Sure.
Bring them in. We've got an exam coming up. It's going to be like a mini, I think it's a pretrial hearing.
Nicholas John Sakala, 26S535-640.
Good morning, Your Honor. Greg Bulahanis on behalf of Nick Sakala. Your Honor, he just went to his vehicle because I asked him, I had him doing AA attendance meetings, and I told him I'd have, even though he hasn't been ordered, I want to see him before I make any representation to you. Here he is right now.
Love my grandkids. OG, 38
And
months.
this occurred on 5/30/2026, Your Honor.
All right, Mr. Sakala, your name?
Oh, he's dressed sharp.
Nicholas John Sakala.
You got to get a lot louder than that. What?
Nicholas John Sakala.
All right, Mr. Bulahanis, your appearance again?
Greg Bulahanis, P36431, on behalf of Nicholas Sakala, Your Honor.
Does he have any priors?
2012, he has a impaired.
Driving?
And this is operating a boat while intoxicated.
Does he stand mute, wait formal reading for
Yes,
purposes
Your
of
Honor.
arraignment?
Yep.
Not guilty, please enter. Well, not guilty, please enter. Were you printed and photographed that night, sir?
Yes.
A lot of these tickets are going to happen
All right.
this weekend. Boat and other influence.
$1,000 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. I want you going to AANA at least one time a week. Again, no alcohol, no marijuana, no illegal drugs. You cannot leave the state, cannot violate a law. You must appear in court as directed. No contact with prosecution witnesses except through your lawyer. So I'm going to ask you to hand him I want him to go at least once a week going forward. Okay, we'll give you a pretrial date.
Your Honor, may I address the bond just briefly? He does a lot of work out of state. His next employment that takes him out of state is July 15th to 21st in Kentucky. He's going to Kentucky. He does go out of work at least once out of state at least once a month for employment purposes anyway. For employment purposes, Your Honor. So could we modify the bond to accept employment purposes?
I will do that. No, so he can leave the state for employment purposes, and specifically, he can also leave between July 15 and July 21. We can give him a pretrial date on the 14th. How's that?
One moment, Your Honor. I did want to indicate I did see his AA attendance sheet, Your Honor, and he's attended 6 meetings already since June 14th.
Okay.
And they're in person.
Okay, good.
One moment.
July 14th at 9:30 we gonna do?
1 second. I'm pretty booked on July 14th, Your Honor. I have 3 hearings in the morning, and couple of them are in person.
I'll do July 21st at 9:30, and your client can appear by Zoom. How's that?
Can we possibly make it at 8:30 because I have an implied consent at 10?
At 8:30, but your client has to be pulled over, okay, if he's driving. July 21 at 8:30, so you can leave the state, sir, and you can appear by Zoom, all right? Good luck.
Thank you so much, Your Honor. I just got the discovery this morning. We're still waiting for video, just so the court's, advise of that.
Good enough. Thank you.
Thank you, Your Honor. You and your staff have a great day.
You too. Chadwick Francois Walls, 26F714814. Ms. Tucker, your name?
Tamika Tucker, P85402, on behalf of Chadwick Walls.
We're almost done. We're waiting for these to
Did you get a hold of him? Where is he?
Your Honor, I do not know. I was assigned this morning, but I did speak to him in the breakout room. I did get a phone number from him. I have called him 6 times since we've been waiting, and left numerous voicemail message with the Zoom, and I am not getting a response.
I don't know what happened, but he was here a long time. I'll tell you what, I'm going to adjourn the PCC. I'm going to set a PCC for July the 7th. So you have to get a hold of him. What time can we do that, Lyndon or Lisa? Then July 14th exam.
9:45.
July 7th at 9:45, July 14th at 10:45. Is that good?
That's great. Oh, sorry.
No, you just have a lot that day. You want to do like 11:15?
Sure. We'll do that.
That's even better.
We'll do that at 11:15, okay?
Thank you, Your Honor.
But 9:45 next week. So make sure you get a hold of him and tell him if he doesn't show up, he's gonna have a warrant issued, all right?
I sure will.
Thank you.
Judge, those 3 tickets that were set on that 8:45 time, only showed up on them, so I'm gonna wait on them. I think that's it though.
As soon as these-
PM and
Are they just department rep or what are they?
AAA Logistics and FBI Express.
This is
Let
the
me
one
see
we
'em.
want.
All set for 8:45.
There's no attorneys on those, Judge.
See here.
These,
All right.
These parties at the tables. That's the one we're
AAA
waiting for.
Logistics Inc., 26S118463. Defendant is responsible, is charged by default. This is a corporation. So send them a notice, Lisa. And then if they don't pay, we'll show cause the president. MBI Express, 26S118469A. We're going to go ahead and find defendant responsible is charged by default. Same thing. If defendant doesn't pay, we will go ahead and issue a show cause against the president. And also I have MBI Express 26S118469B. Same thing. That's just an overheight charge. And they're going to have to understand they're going to be taking care of that. We're going to be show causing the president. Thank you. Daniel Antonio Gomez, 26I712442. Good morning, good morning, everybody.
Good morning, Your Honor. Matthew Methanoff, P58 930.
And James Mikowski, P6215, Green Family Postmaster, Andy Myrick.
Good morning.
And sir, can you state your name for the record?
And no comments.
Okay, today's the date scheduled for preliminary examination. You can be seated, Mr. Gomez. We have, let's see here. 2 counts anyway. 3 counts. Assault with a dangerous weapon, a 4-year, felony firearm, a 2-year. There will be no exam on reckless use of a firearm as set forth in count 3, since that's a misdemeanor. So, any preliminary matters, Mrs. Morrow?
One preliminary matter. The OIC is standing to my right, Detective full name Constantine, and just Second Harris. He did let me know that.
I can't hear you.
He did let me know that, and he has an appointment to get to, so if he could be excused, but closer to that time, so he can go to his appointment.
Any objection?
No objection. I don't think we'll be that long, Judge.
Okay, you can go ahead. Whenever what's your appointment? You need to leave now?
No, I got time.
Okay, so yeah, if you need to leave, you leave. Any other preliminary matters? Mr. Mikowski, any from you?
No, Your Honor.
Call your first witness.
Stephen Jocelyn.
This testimony with this witness, who takes a stand, we're going to see the back of his head in the top left-hand corner. This is where it gets spicy and interesting, I believe. So buckle up.
Come on right up here, sir, to the witness stand. Raise your right hand. And solemnly swear affirmative penalties of perjury that the testimony you will give of these proceedings will be the whole true self you got.
Yes, sir.
Okay, you have a seat. And you may proceed, Ms. Ismail.
Thank you, Your Honor, and good morning, Mr. Jocelyn. Mr. Jocelyn, could you please spell your first and last name?
Stephen. Last name Jocelyn, Josl1N.
Thank you. And Mr. Jocelyn, I want to take you back to May 27, 2026. Do you remember that day?
Yes, I do.
And on that day, were you and Avenir Seller in Ayden?
I'm sorry, Silver Island? Yes, go ahead.
Then, the Township of Rosehill,
Yes,
County of Plain?
yes.
And on that day, were you there earlier in the day or later in the day?
So it was like an afternoon thing.
Okay, was it still bright out or dark?
Oh, it was right out.
Okay, who were you with that day?
So I was with Ashley and our children, or our girls.
Okay, how many kids do you have?
So I have one daughter, or not two kids, but my daughter was there that day, and then Ashley has two daughters.
Okay.
So we're talking about 3 little girls.
Okay, what were you guys doing on Celeron Island?
So the girls like to play at the beach. There's a swing. They like to play in the sand. We were just hanging out.
Okay, were you guys on foot at the beach the whole time? Were you guys on any,
For the most part, yeah.
what do you mean for the most part?
Well, you go to the beach to walk around and play in the sand. So, yeah.
Okay, do you guys have a boat?
Yes.
Were you on a boat as well?
Not me specifically. Nah, I was mostly on foot.
And, but did you have a boat at that location that day?
Yes, I was actually parked on the beach right next to Daniel.
Okay, you stayed at Daniel. Who's Daniel?
Would be the sitting right across from me, right there.
Could you,
Daniel Gomez.
could you tell us what he's wearing?
So it's we have now a white long sleeve button up today.
And your honor, this time we can record what I identify Mr. Gomez.
Record should so reflect.
Thank you. And how was it, you know, Mr. Gomez?
So Mr. Gomez shows up to the beach a lot. That's how I know Mr. Gomez.
Okay, and did something happen between you and Mr. Gomez on May 27th, 2026 that brings you into court today?
Yes.
What happened in that brings you here?
So on that specific day, I got pistol whipped across my face.
Okay. Let's go
I've had that
a little bit
happen, it's not
before
fun.
that. Was there an altercation that occurred before that with Mr. Gomez?
There was an altercation between Mr. Gomez and Ashley.
Okay. Who was Ashley to you?
So Ashley's a girlfriend.
Okay. And then did you witness this altercation?
I was not aware of it until Ashley told me.
Okay, so you were provided information by Ashley,
Correct.
and based on that information, what did you do?
I asked Mr. Gomez why he's trying to start an altercation between me and Ashley.
And where were you and Mr. Gomez?
So I was standing in between the boats.
And does Mr. Gomez
In the water. I was standing in the water next to my boat.
Okay, and then did Mr. Gomez have a boat?
Yes.
And where was his boat in relation to yours?
He was parked right next to me.
Okay, and then you said you were standing in between boats?
Correct. Well, in the water next to mine.
Okay. And where was Mr. Gomez?
At that specific time, he was on his boat.
Okay. And then you stated earlier that you asked him, what did you ask him?
I asked him why he was trying to start an altercation between me and Ashley.
Okay, and what happened after that?
So at this point, Daniel was already on his boat. But that's when he pulled out his pistol and lets 2, maybe 3 rounds go, and then reaches over the side of the boat and pistol whips me with what I believe is a 9mm Glock, all action.
And did you see where Mr. Gomez pulled his gun from?
What was the question?
Did you see where he got the gun from? Was it on a chair? Was it in?
It was on the steering wheel of his boat.
Okay, could you describe it? If you recall what it looks like?
It was black. It looked real similar to a 9mm Glock of what police officers carry on their head.
Okay, and then you stated, did Mr. Gomez say anything to you?
So Mr. Gomez, kept talking, yelling at Ashley.
And where was Ashley?
So Ashley was on the boat recording everything that happened.
And at what point did she start recording?
If you know.
Oh, so she's,
Still, this might possibly be watching, if we could just take care of that real quick, because they're not supposed to be.
We're watching where?
Okay. I apologize.
so
you
can you repeat the question?
Where was Ashley?
Well, no, you asked when did Ashley start recording, if you know?
So Ashley started recording when I told her to, and that was immediately after he had let 2 rounds off in pistol with me.
So none of that was on the recording.
So the recording starts immediately after.
Okay.
Okay.
Immediately after, because I looked right at her and said, start recording.
Okay, so she's on your boat?
She's standing on my boat, on the phone with the Grosio Police Department as she's recording, both at the same time.
And do you recall, where was this firearm pointed? Where was it being pointed when it was let out, or let off?
So it was being pointed towards the beach.
Who was on the beach, if anybody?
So there were the 3 little girls, and then 2 of his other passengers were all running on the beach. So they were already on the beach.
Okay, and how many did you hear go off?
2, potentially 3, before he reached over the side of his boat, pistol at me.
Okay, and then what side of your face, or where were you pistol at?
On the left side of my face.
And how many times?
Right on the temple.
Okay, and how many times were you pistol whipped?
1 time.
And was there any injuries or blood stuff because of this?
Yeah, I mean, it's swelled up. It's swelled up. It hurt over my jaw for a little bit, but that was it.
Okay, and would you recognize the injury you saw today?
Yeah.
Judge, may I share my screen? I didn't want them to.
You may.
Let me just do the breakout.
All right, let's see the picture here. If you can figure out the zoom link. Clickety, clickety, click, click, click. Share screen. Open file. Visible to all. There it goes. Okay.
And Mr. Johnson, if you could just
That'll
turn
buff
around.
out. That'll buff out. No,
And
so that's almost exactly what mine looked like in the same place too.
Yeah, so that was right after it happened. We were actually still at the beach for that picture.
Okay, and is this the injury that you're referring to on your temple?
Yes.
Outside?
Yes.
Does it appear to be an accurate depiction of the injury that you got in this incident?
Yes.
And does it appear to be changed, altered, manipulated in any sort of way?
No, not at all.
I will be moving to the Pickles.
Any objection?
No objection.
People's one is admitted.
Thank you, Your Honor. I'm going to stop sharing my screen. Okay, when this occurred, did you have any weapons?
No, ma'am.
And did you seek any medical attention?
So when I got examined at the Metro Parks, when the ambulance came, they asked me a few questions on if I had felt dizzy or blurriness of vision, and I had answered no to those. So that was their main concern, that and a concussion. There was no signs of that.
Okay, and were the police called?
Yes.
And did they arrive?
Oh, yeah, yes, they were there at the dock waiting for me.
Okay, and then did you speak to the police?
Yes.
Did you let them know what happened?
Was the officer, one of the first ones at the dock.
Okay. And, nothing, bro.
Cross?
Oh, yes. Oh, yes. So, Mr. Jonathan, you've known my client for quite a number of years, haven't you?
Yes, I have.
Because you dated his girlfriend, correct?
He's technically dating my ex-girlfriend.
So, to say that you hang out at the beach with him, that's kind of a misrepresentation of that relationship, isn't it?
So, Mr. Gomez has been going to the beach for many years, just like me. any other people.
Okay, but you've known each other outside of that because he dated your girlfriend, or you stayed with.
No, I only see him and out at the beach. We don't hang out.
Okay,
I don't call him to go get dinner or
okay.
anything.
And you're aware that my client's a 100% disabled military vet, right?
Yes.
Okay. And is it true my client fired one shot?
From what I recall, it was 2, possibly 3.
How much did you have to drink that day, sir?
I think I was drinking water that night.
You were not consuming alcohol.
No, I had my children with me.
So you're claiming that my client was starting something with your current girlfriend,
Yes.
and you
Well, he had his passenger come say something to my girlfriend. He couldn't do it himself.
and you just called and said, please stop doing that?
Well, I asked him why. I asked him if he thought he was going to tell her something she didn't know.
Is it true you were very belligerent?
No, because I mean, unless water gets you belligerent, like.
Okay. All right. So you claim my client fired 1, maybe 2 rounds, 2, 3 maybe rounds.
Not claiming that's what I heard before I got pistol whipped.
Okay. After you were supposedly pistol whipped, what did you do?
I told my girlfriend to start recording so that Daniel could make the news.
And did she record you assaulting my client's passenger in his boat?
No.
And did she record you?
She was
And
not.
I'm sorry, I'm asking you a question.
Okay, guys. Wait.
Like you're telling me.
Wait a second. You can't talk over him.
What do you
Do
say?
you understand what I'm telling you? Listen to me very carefully, please.
Yes.
He's going to ask questions. You're going to supply the answers. If you don't know the answer, you tell him. If you don't remember, you tell him. Okay, so let's back up.
Yeah.
But when I
question?
hang on a second. When I start talking, even if you are, you stop. You understand what I'm telling you?
Only a judge interrupts.
All right. Repeat your last question.
Now go back
Isn't
to
it
sleep.
true that your girlfriend recorded you assaulting the passenger in the boat?
Object to that question, him assaulting a passenger.
Give me the time frame. Was this before or after the incident?
I'm saying what was recorded after the
I was
incident.
told council wanted to see me inside bar.
Did you review the
Wait a
recording?
minute. Wait. Don't just start asking the same question.
That's fine.
Wait a minute. Guys, listen to me. I'm going to tell you what you guys can ask and what you can answer.
Okay.
Okay? I'm going to allow that one question. Was there any indication that you were assaulting the passenger in Mr. Gomez's boat on the video that was taken by your girlfriend? Yes or no?
No.
Ask your next question.
The video that your girlfriend took, it was supposedly after the shots were fired, right?
It was immediately after.
So it was after. Okay. And after these alleged shots were fired, you kept approaching Mr. Gomez's boat. Is that correct?
No. I was standing in between our boats. I was already there. He had a pistol with me. He reached over the side of his boat, pistol with me. So I was already standing right next to my boat, which was in between the 2 boats.
Did you back up? Did you leave?
I took his anchor, set it on his boat, and pushed him off because he had a pistol.
So you were so scared of him, you didn't retreat, but you kept talking to him, and then you went over and unmoved his body. I'm sorry, I'm asking you.
Wait a second. That was multiple questions inside of that. That was a compound question that was going to fourth base. And you don't have the right to interrupt him, sir. Please listen to me. I want you to look at me now.
Fourth base is a home run.
He might be asking questions you don't like or don't want to answer. Don't interrupt him. You show some respect to the witness too. We're going to start with that question again, and you're going to.
I feel like he's not asking a single question.
Sir, if there's an objection to be made, the prosecutor is going to object.
Okay.
Okay? And I'll rule on it. You're not the judge in here. You're not the prosecutor in here. You're not the lawyers in here.
Okay.
Just let him finish the question and answer unless I tell you you're not to. Do you understand?
Yes, sir.
Now, let's make it a more simple question rather than going into hypotheticals with 3 or 4 questions inside of one. Go ahead.
So after these shots were allegedly fired, you didn't retreat, did you? It's a yes or no question.
No, because I was already standing next to my boat.
So you didn't retreat.
I was
Okay.
already there.
All right. So you didn't back off. Isn't it true, Mike? That's not a question. I'll withdraw that question. How many times did my client ask you to back away from him
Never.
prior to discharging the fire?
Never. I kept hearing Lauren Winston is what I remember hearing before I got pistol whipped.
He never warned you. Okay. Your girlfriend starts recording the incident, right?
We've covered this. Wait a minute, slow down. We've covered this. Almost immediately after the gentleman, according to his testimony, your client fired 2 or 3 shots and then pistol whipped him. He told his girlfriend to start recording and she did.
I was going back to give him context somewhere. My next question was going to judge, but I apologize. I'll cut to the chase. So after you didn't retreat.
He said that.
You took his anchor up and unanchored him and pushed him into the water, right?
Correct.
You can step down. Call your next witness. Move the bind over.
Yes.
You agree it's a bad question?
Your Honor, I just want to make a statement here. If we're to believe that the complaining witness story that he had multiple shots fired, like, whether it's 1 or 3, the fact that he didn't back up and he continued the encounter shows, frankly, psychotic behavior.
All right, but that's a question of fact for the jury. I find that the elements of the crimes as charged, felonious assault and felony firearm were committed. There's no reason for me to make any findings on count 3. I'm going to bind the defendant over for further proceedings. The AOI date he's posted his bond of $20,000, 10% will be at 9 a.m. on July the 14th. Counsel, Mrs. Morrow, do you have any objection to the continuation of the bond?
Your Honor, I was going to ask you to have the seller removed based on what we heard. I think there's at least a serious question of fact as to who's the actual aggressor.
But I would object to remove.
I keep the tether on. Bond conditions are continued. Nice to have you here. July 14th. Thank you very much.
Thank you, Judge.
Are we done for the morning?
Yeah, he does have a fat ankle. He has fat ankle syndrome.
You have this one? Oh, is it not mine?
Tether.
Well, I've got to get out. I need to get out of there a little bit.
You can call and see resentment.
Because if not, you can go. For lunch. Take care, Mr. McGowan.
Hey, are you ready?
Your Honor, do you have, can I talk to you, in chambers about something completely unrelated to this case?
Nothing to do with this case?
Nothing whatsoever to do with this case.
Go to lunch.
Sure.
Do you have a moment?
Sure.
We just have a little heart to heart.
I'll put you up in the hallway.
You know I would never talk to him about a case, right? Okay.
You're good, says prosecutor. See ya.
Fine, real quick.
See ya. We gone. So that might be a fun case. That might be a fun case to follow. Okay, I've found a copy of this motion for new trial. Okay. Can I complain just for a minute? Let's get big for a minute. Let's get real. Utah court system. Let's talk for a minute. I think it's fairly apparent that in the world of true crime, Utah is challenging Florida and Georgia for top position as far as weird crimes and criminals go. In that endeavor, it has caused us, as followers of true crime, to visit Utah repeatedly, whether digitally or physically, in order to gather evidence, participate in hearings, and all that. It's great. Utah's a great state. I love it. I don't have anything against the geography. As a matter of fact, I think they have like 5 or 6 national parks, and they're as varied as you could possibly imagine. The only thing they don't have is a quality beach. Okay, but we have some lakes, and the lakes have clear water. It's good swimming. It's cold, but there's that. We have that. Back to the courts, though. I have Googled a lot of things in my life. A lot. When it comes to true crime. I've Googled some pretty crazy facts and histories. I've used AI for some of it to do some deep dive searching for things. But when it comes to Utah court documents, they have their own little Google. They have their own Exchange, is what they call it, Exchange, where you can put in information about a defendant or a case number or a county, and get information about the court case, and you can see all the court cases and the documents. It's beautiful, but why do you charge me 20 cents every time I say search? So if I go in and I go to Exchange and it says enter the defendant name, and I say Kouri Richins, first last name, Kouri Richins, and I hit search, that costs 20 cents. And then it says nothing found, because it's not like Google. It doesn't actually look for it. It's like, oh, you need to put a name and something else for it to work. You left off the last number, so we didn't find the subset of every case that matches the 23159000139. You left off the 9, so we didn't find everything else that matches. We just returned nothing, so you have to search again. Cost another 20 cents. And then Kouri Richins' team makes a motion for a new trial, which I'm about to download. It's not a problem. It costs $1 to download. Great. $1 to download. Then they filed all their exhibits as separate documents. So, motion for a new trial, Exhibit B to motion for a new trial, Exhibit C for motion for a new trial, Exhibit D for motion for a new trial, and Exhibit E for motion for a new trial. I have to pay for each one of these separately because the internet apparently is not free in Utah. That's my complaint. That's where we're going. Anyway, motion for new trial. Purchase. Done. Cha-ching. Oh, and once you buy it, the document comes up in a little window on your screen. And there's a hidden menu system that you cannot... I need to show you this. I kid you not. Let's get this on the screen. All right. You guys can see this now, right? You just can't see me. There you go. Now you can see me. I just paid $1 for this. This is the document we want. It's tiny. trying to read this on the screen is tiny. You can't see it. You can't see it, but up here there are hidden buttons which only appear if you get lucky enough to mouse over them to find a random, let's see, what there's a minus, there's a plus, automatic zoom. Where's one I need? It's got to be over here somewhere. Keep going, nothing. Bing, print. Nope, that's not it. Download. Download document. And it downloads it as document 4. No name, nothing else. So it just goes in my file folder and I have to search for document 4. If I had accidentally closed this, oops. Oh wait, where was that again? Let me find that document. It was right up here. I was on the, it's right here towards the end. Let's see, motion for a new trial. It was this one. You get to purchase it again. It does not track that you bought it once before. If you close the window without saving or printing the document, you will need to purchase it a second time in order to view it again. I don't know how much money Utah has made using this system, which, by the way, let me see what's my total at? Oh man, this docket is massive. Like 1,800 things. I think I need to re-up my money here, but this should help love true crimes. I'm gonna put your money right back into. Once I put it in, this is like you have to pre-feed the meter. You don't just pay as you park and pay for what you use. You have to pre-feed the meter, and then if you decide to use it, you can spend it there. You can never make a withdrawal. But I don't want to. I'll go back to search. Okay, remember this name. Ready? We need to remember. This is the number 231500139. That's our case number. Copy that. We'll go back to search because here's all the different cases. If I have to do this again, it costs another 20 cents. I only have 90 cents remaining. I'm going to fix this. Log out. I need to run down. I think I need to see what's behind my face. What is behind my face? I tell you this. I tell you this because I'm really hoping this doesn't show my credit card details in just a moment. Welcome, Recovery Addict. I'm going to hide my screen just in case for just a second because I think it's about to show you something that I don't want you to see. Okay, make payment. Let's do this card right there. Verifying. Use my thumbprint. I need to enter my billing address. That's it. Pretty sure you can't see this. This is all good. Now I need to prove I'm not a robot because robots steal credit cards and buy things all the time. RXB6 NB. I'm not a robot. Pay now. Loading. Okay, we've re-upped. And I have a transaction I get to print and send to my accountant. Because luckily it's a tax write-off. Oh, but in doing that, it cleared. Oh, joy. Oh, joy. In doing that, it reset us back to a new search form. So we get to search once again for, well, that wasn't the number. That's the one with the error, remember? Don't do it wrong. 231500139. A lot of times when I'm like facing down or looking away or looking like I'm not paying attention or possibly sleeping during court, I'm working through websites like this. Confirm purchase. Are you sure you want to do the search? It will cost you 20 cents. Yes, I'll do it. Oh, there it is. Kouri Richins again. Nice. And there's her trial because we have to buy a couple exhibits really quickly. We're getting exhibity. Please wait while it loads. Loves True Crimes. Thanks. You personally funded this. I'd like to thank you for that. What a pistol whip of a website. Yes, we'll tell the pistol whip story sometime. I'm downloading the file. I downloaded the one we need because I can find it online, but it's like Fox 13's version, and I don't want to. I used to work for Fox 13, Love the channel. I got some good friends over there still, but I don't want to have their logo on my screen while I'm reading you a document for 14 pages because they are not a sponsor. Hold, please. Still loading the docket. Do we have mods today? No, well, we have some, but we're modless because we're court hopping. So it's a calm group today. It's quiet. We're okay. Do we need to get a resident 13-year-old to help you find a workaround? I'm pretty sure finding the workaround. Come on. It's still spinning. This 20 cents better work, or else I have to do the 20 cents again. We're not modless completely, but, you know, Josh wants to be fishing. Okay, it's pulled up. I'm going to grab these other documents for you really quickly. Down at the bottom. Which, by the way, can I just zoom in on something really quickly and show you something? I don't know what this means. Oh, it was the other one. Let's go back to search. This Kouri Richins case right up here. Where is it? No. Is that it? There's a case that had an entry I really wanted to see. Oh, that's a different one. Oh, no, this is the one. It's a different case. Different case entirely. Not Kouri Richins. This is State of Utah versus defendant Gabriel Alexander Monzon. I found this on accident because it had the same case number as Kouri Richins. Jail commitment report. Defendant arrived intoxicated. Okay, that's all. Well, if you know you're going to jail, why not, you know, enjoy the trip? All right. We're going to read a document. The reason why we're going to the Kouri Richins trial today, and I apologize for stalling here while we get this document pulled up, is because Kouri Richins has filed for a new trial, motion for a new trial. We're going to open that with preview. Her lawyers listed on the filing are Wendy Lewis and Alexander Ramos. Her other lawyer is busy with Tyler Robinson. So we'll have this motion for a new trial. This motion for a new trial has caused the judge to recuse himself from the case. Yes, Judge Mrazek, with the deep voice and the incredible patience. We have them on Discord. Why are you buying them? I'm sorry, Queen Lady Wolf. I have a confession. It's easier for me to do it this way because then everything's just on my desktop of my laptop where I keep everything. Do you have all the motions and everything, all the supplemental documents? Can't see them. We're waiting. Let me download these other ones really quickly. I need a clerk. Hold, please. Okay. You have all the exhibits? I'm just checking. Because if you don't have the exhibits, I'll buy them and send them to you. I'm not sure if they have them or not. It's all right, Scottish Roots. We Brits need something to complain about. Too late. I'm buying them. I didn't see your response. Attachment. Download. That's document 5. Close. Attachment C. Purchase. Download. These are court transcripts, by the way. That's document 6. 6 was C. D. Download. document 7. E. Download, that's document 8. That's E, and then we have motion for disqualification, that's certification. I think that might have it. That might have it in there. Let's see what this one is. This might just be a receipt. I might have paid $1 for a receipt, a copy of someone else's receipt. There it is. Yep, we'll download that one as well. Okay, we have them all. So now let's do a little reading. We've got to catch up on Kouri Richins. Let's shrink that one down and bring this one over. RA wants to help support the state of Utah by downloading. Hey, they don't have gambling. They don't have a lot of the other income that other states get from taxes. You know, very little by the way of legalized marijuana. Alcohol in the state is severely limited, and mostly water. They need all help we can get. So, you know, I'll go ahead and give them a little bit of money for these documents. All right, quick read, 14 pages. Lewis and Ramos on behalf of Kouri Richins, pursuant to the Rule of Criminal Procedure 24 and Utah Rule of Civil Procedure 7. Kouri Darden Richins, got to get the D in there. Kouri Darden Richins hereby moves this court to grant a new trial due to irregularities in the trial proceedings and cumulative error, and presents the court an attached video clips and documents in support of her request. I'm guessing my dollar didn't pay for the video clips. Statement of facts. Ms. Richins was originally charged with 1 count of criminal homicide, aggravated murder in violation of Utah Code, and 3 counts of possession of a controlled substance in violation of Utah Code. Prior to the preliminary hearing, that's the one where they decide if there's enough evidence to take it to court, and the trial in this matter, the information was amended and an additional 2 times. A 3-week trial was held commencing February 23rd, 2026. We were there. And concluding on March 16th, 2026, at trial, Ms. Richins was found guilty of 1 count of criminal homicide, aggravated murder. Loves Your Crimes, thank you very much for whatever it needed for. Super generous today. Let's see. Thank you for your support, Loves Your Crimes. That is huge. Let's see. Aggravated murder. 1 count of attempted criminal homicide, aggravated murder pursuant to Utah Code, 2 counts of insurance fraud, and 1 count of forgery pursuant to Utah Code. So that's what the guilties were. Pursuant to Rule 24, the court may grant a new that's undersigned may grant a new trial in the interest of justice if there is any error or impropriety which had a substantial adverse effect upon the rights of the party. That means the error had to have caused a problem, like a guilty verdict because of the error. A new trial is not necessary, however, when an error is insufficiently inconsequential that Utah courts conclude there is no reasonable likelihood that the error affected the outcome of the proceedings. In other words, a new trial is not merited where an error is harmless. Thank you for citing the law. A new motion for a new trial is generally permitted for correcting errors made in the trial court or for reviewing a conviction obtained by unfair or unlawful methods. Ms. Richins' convictions should be vacated and a new trial granted, this is their request, granted for the following reasons. 1, the court's clear demonstration of bias in favor of the state, displayed before the jury, deprived Ms. Richins of a fair trial. Stop for a minute. When did the court display bias? This is Judge Mrazek, right? The deep voice judge, who is so fair and so measured and so thorough in his responses. I don't think the judge has ever been able to demonstrate bias, even in a teaching environment. He doesn't have a bias bone in his body. So we're starting with a big stretch there. 2, the state's repeated reliance on other crimes, wrongs, or bad acts and admission of evidence proving Ms. Richins committed wide-ranging financial crimes over numerous years in several general categories went far beyond the court's pretrial rulings and violated the 401, 402, 403, and 404B, and resulted in substantial undue prejudice, denying Ms. Richins a fair trial and cumulative error. Did they successfully... Let's see. Did they use... Hang on, back up. Demonstration of bias, repeated reliance on other crimes. Okay, never mind. I was looking at the sentence structure, and it's okay. Denied her a fair trial because of the prejudicial amount that they did put it in there. They said deprived her of a fair trial twice in the sentence, which is impressive. Sort of like a chiasm that way. Say it at the beginning and the end. Fun sentence structure. The prejudicial effect of this is a big deal. This is what Alec Murdaugh in part won in his appeal, and why he's getting a new trial. Although it wasn't the sole substance, they would have got one anyway because of the Becky factor. But the appellate court ruled that these other crimes that were loosely associated with this event prejudiced him and should not have played a role that they should have. So maybe the appellate court might hear this, and Kouri might have some grounds there. The argument is the court's repeated assistance to the prosecution and disparate treatment of defense counsel before the jury denied Ms. Richins her right to a fair trial. Throughout trial, the court repeatedly interrupted defense counsel, corrected counsel in ways that suggest to the jury that counsel was mishandling witnesses, assisted the prosecution with its objections, and curtailed the defense's objections. On at least one occasion, the court did so in a manner that made it clear to the jury that it was offended by defense counsel. This misconduct created an appearance of bias against Ms. Richins and in favor of the prosecution, depriving Ms. Richins of a fair trial. If she wins on those grounds, Blaze Taylor gets a new trial too. He has to. He has to, on the same grounds. Because Blaze Taylor's team had just, in their trial, in front of the jury, was exponentially greater than anything we saw in the Kouri Richins trial. Pursuant to the 14th Amendment of the United States Constitution, Article 112 of Section 12 of the Utah Constitution, a defendant has the right to an impartial judge, and the presence of a judge who is not impartial constitutes a structural defect in the trial mechanism that violates the United States Constitution and requires reversal. Structural defect is important because that structural defect does not necessarily have to be objected to at the time to preserve the error for appeal. Right? It's such a foundational problem that even without appeal, it's preserved. The rights are present. These parts in here in the middle where they squeeze all the letters together, this is an excerpt. This is a copy and paste from State v. Maguila. A cardinal principle of our legal system is that the courts of justice act upon the belief that if guilty, a party will be found so after a fair trial. Both the ends and the means of the trial must be fair, and no matter how abhorrent the offense charged or how evident the guilt, an accused has an absolute constitutional right to a fair trial before an impartial judge and an unprejudiced jury. Further, courts have long recognized that a trial judge's comments and actions carry a great deal of influence with the jury. The influence of the trial judge on the jury is necessarily and properly of great weight, and his lightest word or intimation is received with deference and may prove controlling. A trial judge's position before a jury is overpowering. His position makes his slightest action of great weight with the jury. And then State v. Beck was the citation there. In this matter, the court engaged in repeated conduct that denigrated defense counsel both in and out of the presence of the jury. Out should not matter because the jury didn't see it. The court was often impatient, critical, and hostile toward the defense and only the defense. The court frequently interrupted defense counsel, telling them to pause or focus. Never was the state told to focus. Focus? Focus? Don't focus me and spare her. Oh yeah, that's not the movie quote, but it's close. Don't shush me and spare her. That's from A Knight's Tale, I think. During day 4 of the trial, the court interrupted defense counsel on 24 separate occasions while only interrupting the state 13 times. Who's keeping track? Now who has a counter going? Look, never was the state told to focus. The court frequently told us to focus. And then you told us, you interrupted us on 24 times, and you only interrupted them 13 times. That means we're minus 11 in the scorecard. And this isn't golf. This normally may not show bias, but interruptions of defense were curt. Cutting off statements and arguments while interruptions of the prosecution were followed by apologies were often to help with logistical issues or to aid them with objections. We need more data because not all interruptions are equal. What came before the interruption is probably the most important part, other than the fact that there was an interruption. If you were doing something so wrong, so egregious, that the judge sua sponte had to step in to preserve the integrity of the trial, who is really to blame there? Is it the judge for stepping in and saying, whoa, 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 stop, don't do that? Or could it be Ramos or Nestor or Wendy? You never know. This pattern followed throughout the trial. On day 1 alone, the court interrupted the defense 36 times, as opposed to interrupting the prosecution 20 times. There might also be a factor of, who was taking the most time, how many interruptions per minute occurred, right? Maybe the judge just interrupts on a set schedule, and whoever's up at bat at that time is the subject of the interruption. Let's go up to the small print really quickly. See trial. This is a footnote of the focus and the critical and hostile towards the defense. So see trial, day 12, page 146. At the bench, the court generally at the bench. That means we didn't get to hear this part. At the bench, the court angrily criticizes Miss Nestor's objection, telling her to slow her roll and reminding her that to read the ruling that I issued yesterday and try to avoid plain error to help your client further. The court tells Miss Nestor that she needs to wrap it up because I have parent-teacher conference to go to and my son barely recognizes me. I'm sorry. Judge is like, please, for the sake of my son, can we end this sometime today? See attachment A, the video clip of trial, day 4, page 207. The court interrupts Miss Lewis in a demeaning manner, saying, please pause. Please pause. Seconds later, the court follows an interruption of the prosecution with an apology. When Miss Lewis expresses frustration at the court for changing the ruling made at the bench, she is told twice to stay focused. And don't do that. Please stay focused. Oh, the small print's even better. Interruptions of the prosecution were generally clarifying or accommodating or logistical. For example, trial, day 1, page 40, line 17. The court interrupts the state to help clarify their argument and to redirect the state's argument to the court's framing. At page 101, in line 11 through 24, the court interrupts the state, but only to confirm a fact helpful to resolve an issue. At page 312, lines 21 through 25, the court interrupts the state to inform them that their information is helpful. To the contrary, when interrupting the defense, the court uses language such as, "That doesn't track." Page 122, line 14. "Move on." Page 102, line 21. Probably the same conversation. "You're jumping the gun." Page 189, line 9. And "I think it's premature." Page 189, line 23. This is only day one of the trial. A full review of the trial transcript demonstrates that this disparate treatment of the defense was persistent, prejudicial, and well outside the bounds of neutral courtroom management and administration. In addition to speaking in a disparaging and condescending manner to the defense, the court would also reframe arguments in a way to help the prosecution. One strong example of this took place on day 10 of the trial when the defense was attempting to elicit testimony of the victim's prior use of pain pills. Not only did the court interrupt the defense, but it also continuously rephrased the argument, insisting that defense was using the term illicit street drugs, defining street drugs in a way that does not include prescription pain pills. This battle over illicit and the meaning of the word illicit was, I remember it vividly. See attachment A, day 10, page 68, day 10, page 74, day 10, page 93, and day 10, page 95. During this argument, the court did more than frame the issue in terms favorable to the state. It affirmatively accused Miss Nestor of knowingly misusing the court's chosen definition, a definition unsupported by any expert or evidentiary basis, and instead supplied by the court itself. Other examples of the court speaking down to defense counsel are noted at attachment A, day 9, page 20, where the court accuses Miss Nestor of intentionally ignoring what the court is saying and informing defense as an answer to the objection that they call their own witness in their case, thereby burden shifting. At attachment A, day 11, 49 minutes, the court didn't simply rule on Miss Nestor's objection to the court didn't simply rule on Miss Nestor's objection to relevance, but commented on the objection in an extremely disparaging and condescending manner, saying, "You don't see the relevance?" At day 11:57, the court was extremely condescending towards Miss Nestor's request for a continuing objection. At day 14, page 14, the court shot down an objection by Miss Lewis during closing, interrupting her in the process and strongly saying, "Please be seated." This was particularly prejudicial to the defendant as it was in front of the jury, indicating that the court was angry with the defense and making it clear the objections during closing would not be tolerated. The state then went on to make several objectionable statements during closing, leaving the defense with no remedy in front of the jury. Closings are not evidence. Closings are not evidence. In State v. Beck, this is case law, the court addressed this issue, holding that judges must be particularly cautious with their treatment of the counsel in front of the jury, and that the judge's conduct before a jury is critically important because it directly implicates a defendant's constitutional right to a fair trial. When a judge abandons impartiality, the resulting bias can infect the entire proceeding, violate due process, and require reversal of a conviction, regardless of the strength of the evidence. Courts have long recognized that a trial judge's comments and actions carry a great deal of influence with the jury. The influence of a trial judge on the jury is necessarily and properly of great weight, and his lightest word or intimation is received with a deference that may prove controlling. This is a longer excerpt from something we read previously. A trial judge's position before a jury is overpowering. His position makes his slightest action of great weight to the jury. Going on, thus, in order to assure a fair outcome and maintain public confidence in the legal system, it is paramount that the trial judge maintain the appearance of impartiality, especially in jury trials. State v. Gardner, nothing is more damaging to the public confidence in the legal system than the appearance of a bias or prejudice on the part of the judge. And in Mellon, we read, particularly in a jury trial, a judge should maintain an attitude of neutrality and should not, either by his comments or demeanor, indicate his opinions either as to the credibility or evidence or on the disputed issues of fact. A full review of the trial transcript clearly shows that the court was demeaning and condescending to defense counsel. Somebody got their feelings hurt, like totally stepped on. A full review of the trial transcript clearly shows that the court was demeaning and condescending to defense counsel, and in contrast was friendly to the prosecution, often helping them with both their objections and the framing of arguments. Little footnote here to the, let's see, what's the footnote to? It's number 3. No remedy in front of the jury issue. Ms. Nestor did not make a record outside the presence of the jury after closing arguments were complete as to the improper comments made in the state's closing, although, of course, by then, the jury had already heard the improper arguments. So she didn't get to make a record, or she didn't ask to. Going back to the court addressed this, holding that much of this conduct took place in front of the jury. As Beck stated, a trial judge position before a jury is overpowering. Trial judges sit high above everyone else in the courtroom, both literally and figuratively. They preside and they decide. They welcome and protect the jurors, accommodate their schedules, and make sure they have everything they need, including snacks. The influence of the trial judge on the jury is necessarily and properly of great weight, and its lightest word or intimation is received with deference and may prove controlling. They're just repeating the previous thing in there as if it's their own argument. The trial judge often banters and jokes with the jury. We like that. And this case was no different. The jury looked up to the trial judge, laughed at all of his jokes, and engaged favorably with him throughout the trial, at the end clapping and asking for signatures. A full review of the record makes it clear. I'm adding a little bit of commentary, just for those that might be listening and not reading along. They didn't clap or ask for signatures. I just want to make that clear. A full review of the record makes it clear that the court let it be known to the jury that it favored counsel for the state and their positions. When the prosecution raised concerns, the court often accepted, clarified, or helped frame them. When the defense raised concerns, the court more often responded with interruption, correction, skepticism, or curt commands to move on. Judge, can I get a ruling? The ruling's sit down. That wasn't this judge. That was the other one. That was Dozier. In addition to the court's treatment of counsel, a full review of the trial transcript, they've said that several times, full review, shows multiple instances where the court suggested that defense objections could be resolved by the defense calling their own witnesses, thereby shifting the burden by instructing them to put on a defense. The rule, with respect to the scope of cross-examination, continues to be that it is limited to the subject matter of the examination in chief, or in more modern parlance, to the limited scope of the direct examination. While enforcement of this rule generally is within the trial court's discretion, in a close case, the rule must not be so strictly applied as to deprive the defense of an opportunity to present the jury a vital element of the defense, here government inducement, an element of the entrapment defense on which the accused has the burden of proof. So what they're saying here is, we know that the rule is the person who calls the witness asks the questions, and the defense gets to respond to those questions. You can't ask things that are well without that range. The judge did enforce that, probably tighter than many judges we watch. And that is trial court's discretion. Let me just say, if he has discretion to do that, the appeals court's not going to turn it over on that reason. In a particularly heated debate with defense counsel regarding argument over the state's request to put in additional statements by Carmen Lauber after she had already taken the stand, the court told defense they should recall Miss Lauber in their case if they wanted to question her on these statements that the state did not put in during her testimony. At times, the court went so far as to tell the defense to put the defendant on the stand rather than allowing certain lines of questioning. That was within his discretion. And we've got the citation for day 7. In addition to disparaging defense counsel, the court repeatedly aided the prosecution by supplying objections the state had not made, and on at least one occasion, sua sponte objected on the state's behalf and then sustained his own objection. I will sustain my own objection. Do we have that soundbite? Can somebody trigger that one? I think it's exclamation point own.
I'm going to sustain my own objection.
There's one. Yeah, so it happens occasionally. So sua sponte. This is interesting because the court supplying objections the state had not made, sometimes you will have a situation where the defense or the state will stand up and say objection, and the judge might say hearsay, sustained. That is not necessarily supplying the objection. That is the lawyer objecting, saying, this is so obvious, judge, you can see what the problem is, right? And the judge saying, yeah, I see it. So it's not the same. Sua sponte is a little different, where the judge is like, wait, I object. That's different. Day 13, they have some sites on that where the judge sustained his own objection. We might have to read that one. Although a trial judge may control the courtroom and rule on objections, the court may not abandon the role of neutral arbiter and assume the role of advocate for one side. The Supreme Court has long cautioned that judges' influence over jury is uniquely powerful, and that even the slight judicial intimations may affect the jury's view of the parties and the evidence. I don't know, when I was in English, when I was in high school, writing papers and all, and even in college, it was frowned upon to use the same citation over and over. But in the legal world, it's okay, because we've heard this same clip, this same copy and paste, probably 4 times now, and we're only halfway through the document. Utah courts recognize the same principle. A judge must maintain both actual neutrality and the appearance of neutrality, particularly in a jury trial, because judicial comments and conduct suggesting favoritism can undermine public confidence, as does kicking the media out, and deprive the accused of a fair trial. When the court supplied objections for the prosecution and then sustained those objections, the court did more than manage the proceedings. It communicated to the jury that the state's position and the court's approval, and that the defense's questioning warranted judicial intervention even when the prosecution itself did not object. That appearance of alignment with the prosecution is precisely the type of conduct that can infect the fairness of the trial and requires a new trial. All right, Cherie, thank you very much. I paid for them again already. If you don't have a clean copy, I'll send you mine. If yours have like Fox's logo or something on them. Overall, based on the court's conduct, it often appeared that the defendant was not facing a single adversary, but rather had to bear the consequence of a judge who at times acted as a second adversary and who appeared to disbelieve either defense counsel or a defense witness. Your Honor, we are not just playing baseball against an opposing team, but the referee himself, the umpire, is catching foul balls and striking out batters. They're saying that the judge was playing ball when he was supposed to just umpire. As a result of the court's repeated judicial conduct toward the defense in this case, the defendant did not receive a fair trial by a neutral arbiter of justice. Because Ms. Richins is asserting herein a claim of bias on the part of the judge, the court should reassign the consideration of this motion to another judge in compliance with Utah Code of Judicial Conduct. This is where they're using the law to get what they want, and they're going to get it. A judge shall, not may, but shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. The judge has a personal bias or prejudice concerning a party or a party's lawyer. The Utah Code of Judicial Conduct defines impartiality as the absence of bias or prejudice in favor of or against particular parties, as well as the presence of an objective and open mind in considering matters that come before the judge. There's the citation. Even most scrupulous, there's the word I was looking for, scrupulous efforts to keep an objective and open mind are near impossible when a judge is being asked to consider whether his own behavior was prejudicial during trial. Due process guarantees an absence of actual bias on the part of the judge. Bias is easy to attribute to others and difficult to discern in oneself. To establish an enforceable and workable framework, the court's precedents apply to an objective standard that in the usual case, avoids having to determine whether actual bias is present. The court asks not whether a judge harbors an actual subjective bias, but instead whether, as an objective matter, the average judge in his position is likely to be neutral, or whether there is an unconstitutional potential for bias. So what the court is basically saying with this is, when a judge is accused of being biased, of not being that fair and impartial arbiter, the way that's handled is in a way that will avoid the appearance of bias. Because if it goes to the judge and you say, "Judge, you're not being fair, you're not impartial, you clearly like them better than us," and the judge says, let me think about that. No, I'm going to rule against you and in favor of them. I'm not biased. I'm not biased. That looks bad, even if it's true, 100% true. So the state is going to get what they want here with their accusal of the judge. The state's repeated reliance on other crimes. This is part 2. So we've switched from the impartiality of the judge to the other issue of why she wants a new trial. States' repeated reliance on other crimes, wrongs, or bad acts, and the admission of evidence proving Ms. Richins committed wide-ranging financial crimes over numerous years in several general categories went far beyond the court's pretrial rulings, violated 401, 402, 403, 404B, and resulted in substantial undue prejudice, denying Ms. Richins a fair trial. Prior to trial, the defense filed motions in limine, a lot of them, seeking to exclude from trial evidence of over 30 other crimes. I'm sorry, at what point does that become very probative in someone's life? Okay. 30 other crimes, wrongs, or bad acts connected to Ms. Richins' business or her financial dealings over a period of several years. On January 7th, the court held a hearing to determine to what extent all of Ms. Richins' alleged financial misdeeds, spanning years before Eric Richins' death, could be admitted at trial. The court gave the state some general guardrails, attempting to avoid 404B issues at trial. See Attachment B, partial hearing transcripts. In trial, the state went far beyond the court's pretrial rulings and introduced the testimony of Chelsea Barney and Brooke Carrington, going into great detail about numerous financial misdeeds. See Attachments C and D. Ms. Carrington spent an entire day on the stand testifying about bounced checks, false bank statements, misleading communications with lenders, mismanagement of business affairs, sloppy accounting, improper tax accounting, and on and on and on. Ms. Barney testified about how she lost her life savings and her home when Ms. Richins mishandled a real estate transaction for her and allegedly lied about it. The defense objected to all of the state's attempts to inject allegations of financial and business fraud or other dishonesty into the trial, despite the court's pretrial rulings, and each and every objection was overruled by the court. See Attachments C and D. The very beginning of the state's closing argument specifically referred to Ms. Richins taking out a HELOC without her husband knowing about it years before he died. See Attachment E. 7 pages of state's closing argument focus on the testimony of Carrington and Barney. That's in Attachment E. Ms. Richins' case is similar to the case of State of South Carolina v. Richard Alexander Murdaugh. Ooh, did we just mention that? Did they just see this in the news and think, hey, it's good for Goose Murdaugh, it's good for Gander Richins? South Carolina Supreme Court, May 13, 2026, wherein the Supreme Court for the state of South Carolina held that it was overly prejudicial to allow the state, under the guise of proving motive, to introduce vast amounts of evidence showing financial misdeeds that the defendant spanning years of time prior to the murders of his family. Like the Murdaugh case, Ms. Richins was denied a fair trial due to the undue prejudice of financial wrongdoings permitting her trial. The only appropriate remedy is a new trial. Like the Murdaugh case. Judge, we're the same. We're the same. Alec and I are like, Alec and Kouri are buds. Both accused of offing family members. Samesies, right? We're like twinners. Alternatively, the court should grant Ms. Richins a new trial under the cumulative error doctrine. Under the cumulative error doctrine, a conviction should be reversed when 2 or more errors occurred. Each error, standing alone, has a conceivable potential for harm, and the cumulative effect of those errors undermines the court's confidence that a fair trial was had. A court's confidence is more likely to be shaken when the errors work together in a pernicious manner so as to cause more prejudice than the mere sum of the individual errors. Cumulative error refers to the number of errors which prejudice a defendant's right to a fair trial. It builds up over time, right? Each offense makes it bigger and bigger. The cumulative error doctrine applies when a single error may not constitute grounds for reversal, but many errors, when taken collectively, do. It's like arsenic, right? Remember in the As You Wish movie, the Princess Bride movie, and Wesley does the whole mind game switch about with the poison in the drinks with the really smart guy, and he chooses one and drinks it. They both had poison in it, but Wesley over time had built up a tolerance. Well, in this case, a little bit over and over and over a long time adds up to death, and it doesn't build up to tolerance. So it's the reverse of that one. Bad example. The cumulative error requires reversal if the cumulative effect of the several errors undermines the court's confidence that a fair trial was had. Importantly, the doctrine applies only to errors that are substantial enough to accumulate. It does not apply to errors found to be so minor as to result in no harm. When considering reversal under the cumulative error doctrine, not only must a court make a determination that an error exists, but it must also make a separate determination that the error could conceivably cause some harm before it adds the error's effect to the cumulative error scale. So let me give you a better example. If the judge welcomed everyone to trial and said, I'd like to welcome you to Kouri Richins' trial, that on its own is bad. Sentencing would infer guilt, right? But it's a correction. It's a, oops, I misspoke. How embarrassing. On its own, it's fine. If every time the jury came in, the judge said, we're now on day 16 of Kouri Richins' sentencing, oops, trial, that would build up. And the jury's like, oh man, sentencing. The judge thinks she's guilty. The judge thinks she's guilty. So that would be cumulative error. If 60 times during the trial, the judge referred to this trial as actually Kouri Richins' sentencing. The court should recuse from consideration. This is their conclusion. This is their ask. The court should recuse from consideration of this motion, and evidentiary hearing should be scheduled before the judge assigned to the motion to present evidence and argument in support of Richins' request for a motion for new trial. Well, all that means is Judge Mrazek, you don't get to decide this. Someone else has to look at this. And guess what? Judge Mrazek agreed. So here we have a response. We're going to go up here to continuous scroll, make it big. The order of the court is stated below, and it's under Judge Mrazek's label. Ruling, certified motion for disqualification to reviewing judge. Before the court is defendant's motion for new trial. On pages 10 and 11, the motion states in part that because Ms. Richins is asserting herein a claim of bias on the part of the judge, the court should reassign the consideration of this motion to another judge in compliance with the Utah Code of Judicial Conduct. Given the apparent objective bias discussed, the actual conflict of interest created by allegations of the court's bias, and the need to ensure due process, disqualification from ruling on this motion is warranted. Out of an abundance of caution, the court interprets the foregoing as a motion to disqualify under Rule 29B and the Utah Rules of Criminal Procedure. Now, who's helping who? Defense did not file the proper motion to recuse. They didn't file the wording was not there, okay? And the judge says, I think what you mean is you want me to recuse myself, so I'm going to do that for you, right? Because that's the kind of judge I am. Under Rule 29B-2A, the court hereby certifies the motion of the associate presiding judge of the 3rd District for review. This court shall take no further action in this case until the motion is decided. End of order. So Judge Mrazek is gone. He's off the case, and someone else will get to decide if after reading the transcript, watching the videos, looking at the supplemental documents, which I bought but did not read, and decide if Kouri gets a new trial, because she, like Alec Murdaugh, was prejudiced in her trial by the prevalence of other acts, of other crimes, of other bad behavior. And she might win, but she probably won't. And the reason why, in both cases, the court, well, we haven't had a ruling on Kouri Richins yet, but we have had rulings on the evidence through motions of limine and the pretrial ruling. So I have knowledge of the court's mind regarding Kouri Richins' case going into the trial, and we have knowledge of the Supreme Court's mind of the Alec Murdaugh trial after appeal. Even though Alec Murdaugh was granted an appeal, the court did not order that in the future trial no mention of financial crimes may be brought up. They just said it should play a smaller role in the Alec Murdaugh trial. And they had like 99 instances of this.
And now at Murdaugh stole it. Alec stole it as well. Alec stole it. And now at Murdaugh stole it as well.
It was the whole court was just over and over and over. Alec stole it. Alec stole it. Alec stole it. That was too much. So they say it should be less. In Kouri's case, they already only used a subset. They already only used a little bit. They pared down. They excluded financial crimes that were outside the scope, even though they may have started and built up and been part of the big snowball which led to this crime. But they excluded some. Yeah, thanks, Becky. This is why we can't have good things. Who stole it? Nobody knows. Nobody knows. All right. Where are we? It's noon right now. Let's see if we have any questions. Can we sit through enough of her face facing? Kouri had some faces for sure. Would a new trial allow the evidence that was left out in the first trial? For example, fentanyl was found in her house. A new trial resets back to the point in the prosecution where charges have been filed and a date is set for court. So there would be new motions in limine. There could be different witnesses. There could be a different, I believe the charges could be changed if the state wanted to do that. Things could be left out. Things could be added. It is like an entirely new trial. It could happen very differently. It might have a different prosecutor on it. You know, there's a lot of things they can do differently in a new trial. Can you explain this to me with the candy bars? No, I promised a friend not to talk about food. So I'm trying. It's hard. Hey, greeters. Let's see. Anything else? Queen Lady Wolf, thanks, by the way, for the word about Discord. Let me put in a word for Discord just briefly. I don't use it extremely often, but it is an amazing asset. If you follow a lot of cases, especially some that maybe don't hit the mainstream of true crime, right? Maybe Court TV is not covering this one, or what happens? Where's this particular case at that's not ready to go to trial yet? Discord, as the gavel drops, is your source for that. That is, they have, I don't know how many amazing web crawling sleuths that are digging up information and articles and news stories and videos and evidence and filings on all these cases. And Amber's our founder in Discord, yes. So do give it a shot. It can be tricky to get into to understand how it works, because Discord just does its Discord thing at the beginning. Once you understand how it works, it's amazing how much information there is out there. It's wonderful. So worth a try, and big shout out to them. They've been partners with us since the beginning on our side. Did you see the pictures of the ESB climbers? She had crazy long nails and knee-high boots. The Empire State Building, holy smokes. I don't know how much they climbed. I don't think they climbed like the outside of the whole building. They sort of like got up to the top and then did the last 75 feet on their own, and it's basically a ladder. I mean, it's a ladder on top of the world, but it's a ladder. It's designed to be climbed. The light on top needs to be replaced every 5 years. So somebody's able to climb that. So a little crazy. But she said yes, and now they have, jail to think about it. All right. Sloth Life, how are you doing? Thank you. Welcome. Good to have you here. How are you feeling? Twin Tail Fox is here. I'm rescuing 2 kittens. My sister is picking them up tomorrow for me since I'm in Reykjavik. Is it Reykjavik or Reykjavik? But still, I'll be home on Sunday or Saturday and Sunday. Awesome. Heat wave in Michigan, too. So is there an emergency hearing on Karen Reed today? I didn't pay close attention to when they were going to do it. It was right at the end of the video. The judge gave the date. We'll get baby kitten pictures. Oh good. There's nothing better than baby kitten pictures. Oh no, I missed some chats while I was reading. I apologize, Sloth Life. Let me go back and take a look at these. Sloth Life says, "Sheesh," and they sat the Scots. And they say the Scots are tight. I used to think they got us confused with the English, but might be the Yanks. I think you're talking about the Utah being stingy with their court documents. And now breathe, everyone. Oh, I missed a whole ton. Let me go back and make sure everyone got put on the screen who deserves it. All of you do. But Corey Hill, thank you very much. Judy, thank you. Baby Shark, wonderful to have you here. Brenda Meyer, MSCJ, Aunt Karen, and DMB Secondus, Unholy Saint 1, all of you, OGs with over 30 months. OG! But we're not done there. Let's see, went to Unholy Saint. Adri Horak, 8 months there. 19 months with Taz. Thanks, Taz, for being here. Let's see, Jay McCarthy World gifted 5 memberships. The other Emily, 27 months. OG. The corruption in mass runs so deep, in my opinion, that those in power are willing to do anything to keep it. Doesn't want publicity. Streisand effect, Judge. Then Sloth Life, thank you very much for the breathing reminder. Love my grandkids. Member for 38 months. OG. Loves True Crimes. Paid for our documents that we read today. Thank you very much for that. Amanda H. Utah Court Fund. Thank you. Chipping in. Yogi Kaz gifted a membership. Sloth Life once again says Utah is stingy. I don't know. It's ridiculous. Knowing the cost of stuff, they're not using AI supercomputers to process, machine learning stuff. That stuff's expensive. That requires massive data centers. This is just a simple database search in Utah, and they charge through the nose. They charge more for usage than I pay for my heavy Grok usage, which is a lot. I mean, I have it do writing programs for me. Loves True Crimes. Thank you very much for your generosity. You're amazing. Regina Adams, member for 35 months. 1 more month. Thank you for all you do. Yes, 1 more month, and you will get the red courthouse. Gaily May, missed my member anniversary. 38 months, Gaily May. OG for both of you guys. Wogger, member for 16 months. Just humble little orange courthouse here. That's all. Just orange. It's wonderful. Thank you very much. And let's see. My son turns 30 on July 10th. Melissa, happy birthday in advance. We'll sing to him if we get his name. Just glad it's not in Florida for once. Oh, there's plenty going on in Florida and Georgia. I think we might actually be talking about a Georgia story tonight on the podcast a little bit. So between bites of food. Food will be on the podcast tonight. There's going to be some food. All right. Anything else we have to cover this morning?
You are banished from the state of Georgia.
I am. But we can talk about it from a distance. It's cheese night, yes. For some reason, YouTube has made me forever gray. Pam Graham, don't give up hope. 80s Music Man was in that state for years, like literally years, and received a gift within the last month. So there's still hope. I was here, RA, when you and Mrs. RA were cooking together. That's awesome, JBs. Good times. We still cook together, just not always on screen. All right. So I was just asked, what was our next case? Yogi, let me give you the schedule. Thank you for asking, first of all. The schedule goes like this. Tomorrow is July 3rd. We're anticipating taking that day off because it's July 4th, and it's the 250th birthday of our nation. The family and I are going to go, at least in the evening, and watch a drone show instead of a fireworks show, because the whole state's, like, all the U.S. is on fire or about to be on fire. So fireworks shows are very risky right now. Some states have banned fireworks almost entirely. But drone shows apparently don't cause as many fires. So we're going to go to one of those. I would love to live stream it if I could swing it. And maybe I can get Mrs. R.A. to okay that. Maybe I'll set up a camera up on the roof of the car and live stream the whole thing. That would be fun. So I'll talk to her and see if that works. And then the other thing we're doing, then we're going Saturday. Let's see, today's podcast tonight. Then tomorrow we're taking the day off. Saturday we're going to go to a celebration, one of the locals. I think there's some towns along the Outer Banks that do like some fun family events. We're going to one of those. And then we'll be back on Monday with the Tyler Robinson hearing. Monday is the 6th, right? Check the calendar. Yes, the 6th is the Tyler Robinson hearing out of Utah. So that's going to start for us right just before lunchtime, I think. So we'll probably do our morning meetup and maybe some court hopping or some updates about any news that happened over the weekend, and then go to Tyler Robinson with the clean feed. I'm going to do Tyler Robinson only on Recovery Addict. I'm not putting out a clean feed on Top Mark Media. There's plenty of clean feeds out there for that because there's just so much coverage. You can find an almost perfectly clean feed on East Idaho News. Most of the media, whether it's Fox 13, KSL 5, Channel 2, Channel 4, out of Utah, most of those are going to have a clean feed going on YouTube as well. So I just don't think I can add anything else by doing that, and I want to do commentary as well. So that will start Monday, and that will take us through most of the week. That is going to be a huge case. I can tell you that I'm 99.99% sure what the outcome of that preliminary hearing is going to be, and he's going to be bound over for trial. The judge is going to find that there's sufficient evidence that warrants this going to trial in front of a jury. So the outcome of that case or that hearing is not the big deal. We're not waiting to see if it's going to, is he guilty? Is there enough proof to take him to trial? That's not an issue. I think they have some pretty strong evidence to support their case. What is at issue is some of the evidence that's going to be brought in and shown is new that we haven't heard. And this case has, maybe because it's so popular, because so many people have talked about it or seen it or discussed it or have theories about it or conspiracy theories about it, there is a lot of misinformation out there. And I'm not saying which one's right and which one's wrong, but there's a lot of misinformation because there's a lot of conflicting information, and it can't all be right. Some of the evidence that we're going to get during that trial is going to help us understand better what the prosecution thinks happened. And that's going to be quite telling for the direction of the case. It might clear up a lot of the misconceptions and the crazy part that's out there, because there are some crazy parts. But we're going to see a lot of evidence, not all of it. Because remember, in this hearing, the judge has agreed to allow the defense to argue the admissibility of the evidence in front of the public, namely the media, whether or not it should be shown to the media separately from whether or not it should be allowed in court. So it's all going to be allowed in court pretty much. And each item as it's brought up can be objected to by the defense or the state in theory if they wanted to, but I don't think they will, to see if the media should be excluded. So we're going to have a lot of mini battles where where the defense is going to argue that the media should not be able to see whatever it is. Most of those we're going to win. Some of those we won't. Some of those that we won't win, I think, might have to do with any witness who is underage, if they have any of those that are brought in for this hearing, and maybe some that are quite graphic. Those may be excluded. And there are both of those in this trial. So I do expect that some of the things we'll be staring at the wall for, or looking at the great seal of the state of Utah, or the flag, or a light bulb, or a ceiling fan for part of the trial. Who is this misinformation? She sounds like a smart woman. Yes. I can't believe you're not making time for Taylor Swift's wedding. Ladybug's mom, I have gone through my mail. I don't know where my invite was. I was sure she would invite me. Maybe the mailman stole it. I don't know. My birthday on July 18th falls on a Saturday, so I'll miss you singing. I'll sing to you on a Friday, JBZ. That's what we do. If it's on Saturday, we sing on Friday. If it's on Sunday, we sing on Monday. Make sure you add yourself to the birthday list so we don't forget, though. It was an Evite. Oh, I don't read my email. That's the problem. Queen Lady Wolf says, we have all the Tyler documents on Discord, too. Let us know if you need them. Thank you. Thank you for those. I think Selena K., you were looking for the decorum order for the pretrial hearing or for the preliminary hearing. I'm not sure if there's been a formal decorum order document out, but I would check Discord for that first. I know the judge has made some rulings about that, but I'm not sure if they filed. I still haven't seen an actual decorum order come out. Let's see. Anything else? I think we can go to lunch, but I'm not sure if we have something for the afternoon, which means we can either court hop, because this is sort of our last day in court together and before the holiday. We can come back and court hop this afternoon if you'd like, or you guys can all pray that something terrible happens around my neck of the woods and we can run out and see if we can film that live. I'm open to either, honestly. I'm okay either way, however that goes. We need a police chase, obviously. We could court hop. Let me see. Let me just take a quick peek at who's live today. Looks like Judge Dad was. We had some Minecraft court. Thurston County. Hang on. Is that? If Thurston County's doing civil stuff, that would be the best. Judge Simpson was live today, so we have some of that. Judge Simmons. Yeah, well, we'll have a few things to watch. Let me build a court hopping placeholder so you guys know we're coming back. I have a call. Hang on. I think it's Selena.
Call from Selena.
Selena, I memorized your number. I recognize you. How are you doing?
I'm doing well. How are you?
Just absolutely fabulous. What's on your mind? Hello? Are you there?
Can you hear me?
I can hear you now. I'm doing really well. How are you doing?
Okay, I'm doing well. I just calling about Tyler Robinson. I'm planning on going on Monday.
Okay. It's going to be packed. Like more so than the Kouri Richins thing. This is a big one. Selena, I think you're not hearing my responses.
Hold on.
Hold, please.
Okay, is that better?
It still sounds the same for me. Can you hear me now?
I can.
Okay. I was going to say, if you're going on Monday, it is going to be packed, much more than the Kouri Richins. I realize it's closer to you, so less of a drive, or it's probably about the same, actually. But
Right.
be aware that everyone and their dogs is going to be there, especially now that we heard that that the family is going to be present, at least on Monday.
Family's going to be there. Yeah.
That would be awesome if you go. We'd love to have you as a court watcher. Obviously, there's no jury to watch at this point. This is just a preliminary hearing, pretrial. But how are the fires in Utah, by the way? She can't hear us anymore.
I can hear you.
You're not responding to the question I asked, so I'm not sure if you're hearing it.
I'm hearing you later.
Oh, you're watching the live stream?
Hold on, let me go off. Okay, now it's better. Ask me again, sorry.
We asked how the fires were in Utah.
Oh my goodness. The one fire, Eureka finally got to go back home, and then they were evacuated again, but now they're back home. Lots of heat damage to houses, nothing burned, but now they're talking about there was some extra toxic stuff that burned in the Eureka one that the firefighters were exposed to. So that's just been a breaking news this morning.
Yeah, Eureka, for those that aren't familiar, they have everything from uranium mines to, it's a mining town. So they have chemicals for processing, mining tailings, and the mine places themselves. That's where the fire was burning. So when you burn chemicals, bad things happen. Eureka is a beautiful old area to go explore, or at least it was. I've loved hanging out down there and poking around. Dangerous, but fun.
It still is. When I thought it was going to burn down, I was very sad because it's a historic little town, and some of the buildings are, have been. I don't know what they do when the state declares them historical buildings there and stuff. So. It would have, yeah. But now I'm feeling really worried for the firefighters to see how that's going to go down. But I turned off the live stream. Now I think I can hear you. But I am planning on going to Charlie Kirk Tyler Robinson Monday. But it's not as far, but I am going to have to be there. I'm going to be there around 2-ish just to see how it goes. So.
Yeah. 2 in the morning is quite a commitment, so that's more than I'm willing
I'm not
to do.
sure I'll be there every day. I know I won't be there every day. It all depends on how Warren's health goes. Yeah. So if he's okay, I will go Monday, but I will text you and let you know.
Okay, sounds great. Please stay safe. Take snacks in a chair. So. I would say stay warm, but I don't think that's the problem.
At least it won't be cold.
Yeah.
We won't be cold this time.
Yep. Selena, good luck. And we hope to hear from you. Yeah.
I just wanted to say one more thing real quick. If Kouri Richins does get a retrial, I'm not going. Just saying. Once is enough of that one. Yeah, so anyway, toodles.
Thank you. We'll see you, Selena. Bye-bye.
Okay, bye.
That's awesome. So yeah, when she says she'll be there at 2:00, that is 2:00 in the morning for a trial that will start around lunchtime East Coast time. That's a lot of dedication. So big shout out to her. It does, in some of these big cases especially, it takes a lot of planning to be able to get one of those coveted seats in the courtroom and actually see it. All right, best wishes to Warren, obviously. Thank you very much for those in chat. All right, I was building a portal when I so rudely interrupted myself. All right, here we go. We'll have live chat, subscribers, no live reactions, visibility. Public starts at, let's come back at 1:30. That'll give us just under an hour for lunch. And then we have to make it ultra low latency, enable auto start. This is important. If I don't do this, then, I can't do that until after I stop this feed. If I don't enable auto start, then I just talk to myself without clicking that button. So, all right. It's lunchtime. We have some more interesting court stuff to follow. Some of our favorites. We're going to be hopping around, seeing what's up in their courts this afternoon. And then a big pretrial hearing, preliminary hearing for Tyler Robinson next week. Podcast tonight. It's going to be a lot of fun. Join us for that as well. We've got some fun stories to talk about. And we have a portal set up. So we are going to be back this afternoon. You can count on it. It's going to happen in an hour. There's the portal. All right. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in 1 hour at 1:30 Eastern Coast time. We'll see you guys in a little bit. Bye-bye.